Is recognized.
I'm Ann Spillane from the Governor's Office, General Counsel. Thank you. I'm Ann Spillane from the Governor's Office, General Counsel.
Hi, my name is Joanne Olson. I'm the Deputy Chief of Staff at the Illinois Department of Public Health.
Well, good afternoon. Thank you, Mr. Chairman. First, let me start by saying thank you to you for the, I'm over here. I know with the mask, it's really hard to figure out who's talking, right?
Yeah.
The effort that got put in last week and the communication and the collaboration, I think, was valuable and helpful to everyone involved. And I want to say thank you for the efforts that were made and the communication that we got to have. I think we got to a better place than we would have been at the beginning of the week. So again, I want to say thank you for that. I have several questions I'd like to ask, just to get some things on the record and get some clarity for those who have questions about this, because there's been a number of drafts that have been made. I don't know if they're made public, but they got in the public, and there's questions about those things. So I'd like to ask a few questions regarding that part of it. One of the important ones that I got had to do with when a person has someone come to their business and they are not wearing a face covering, but they're not medically able to tolerate a face covering. How is the business owner or the people in the business establishment, how are they to make that kind of determination? What should they do? What's the procedure they should follow?
What we have recommended, and again, I think this will be different based on the facts and circumstances of the business, but we have recommended as examples written into the rule that a business posts signage, for instance, that a mask is required, that a business ensure to the greatest extent possible that their employees are wearing masks. If it is feasible for the business that they have masks that they could give to customers, that will not at all be feasible for every business, and that they consider asking an individual to wear a mask. If an individual replies that they can't wear one for medical reasons, we do not expect a business to dig deeper into that. We do not expect the business to suddenly become medical experts and ask follow-up questions. We have deliberately written the rule not to put in place specific narrow medical criteria. The goal here is not for individuals running businesses to suddenly have to become medical doctors. If someone says that they're not able medically to wear one, they can't tolerate it, that's the end of the inquiry.
Okay, so then if that happens, I'm just trying to play this out in my mind here, there will be no follow-up, and I believe that's in line with what the Department of Human Rights is their guidance, that you should not be asking any questions about things. There's other HIPAA implications, I think, for businesses who are involved in the medical field already in that regard. I guess the question then becomes if someone takes a picture of a person not wearing a mask, but they don't know that it's a medical issue that pertains to that, is the business need to document that in any way, shape, or form? In case someone comes and asks questions of why people weren't wearing masks in their establishment earlier, is there any guidance or recommendation there as to what the business should do to be as much in compliance as possible with that situation?
Right. Again, I think this will depend on the facts and circumstances of the individual business. When you're talking about businesses that are very large and are seeing tons and tons of customers coming in and out, that documentation is not likely to be feasible. If it is feasible, I would recommend they do that, but again, that's going to be based on the circumstances. What we have tried to make clear, and I'm happy to answer as many hypotheticals as necessary, is that businesses are not expected to achieve 100% compliance here. Businesses are asked to take reasonable efforts, signage requiring that people wear masks, providing masks if possible. Again, that will not be possible for all businesses. Asking customers to wear a mask. And conceivably, if it is possible for a business, asking a customer not wearing a mask to leave and having that discussion with the customer. Again, that will not always be feasible or recommended for safety reasons. It's going to depend on the individual circumstances.
Okay, I appreciate that, because and especially the last part you said there, it becomes very difficult for certain situations. I think if we can all imagine a situation where you might be intimidated by someone or their attitude, the way that they approach themselves. They may also be upset about other things. They may have medical issues that you can't ascertain. So we don't want to necessarily dive into that part of it. I don't want a business owner to be, or an employee of a business to get themselves in any kind of trouble based on the fact that they took the first 3 steps you outlined. Those were done correctly. They complied with the general idea behind this this rule, but they couldn't do the last one because, for other reasons. That shouldn't be something that they necessarily become held accountable for if someone else makes a judgment against them as far as the violation of this rule. And I guess that's kind of the difficult part of this rule, because the reasonable efforts, while definitely a better standard than no standard at all, isn't specifically a standard that everyone's going to be able to follow. And the way people are perceiving this out in the real world, and the calls I've gotten, the hundreds of emails that my office has gotten, has to do with, hey, if someone comes to my business and they don't follow the instructions that I give them on the door, they don't follow my instructions when I verbally ask them to consider wearing a mask, I could somehow be held liable, and ultimately, if this happens repeatedly with maybe a very ambitious health department employee, that I could be charged with a Class A misdemeanor eventually here as a business. And there's real concerns about that. And I understand that if we had a different set of standards here than reasonable efforts, and I understand that idea of having flexibility, but I also think that on a legal and criminal element of this, we should be considering maybe a more specific, stricter set of things that people comply with. Because I believe, in my experience, a lot of the emails that I'm getting aren't from people who want to flout the rule or the intent of this. They're businesses who really want to comply and do this correctly, because they want, more than anything else, people to be healthy. At the same time, they don't exist if they don't stay open and serve customers.
Yes.
So that balance has to be stricken here. I believe there's a better way for us to accomplish that. And we can talk more about that in a second, but I really think that element is do you foresee another path, and we talked about this on the phone, I think, last Friday, of another standard that might be more, clearer, more precise for a business to be able to follow, or any of the affected entities that this rule covers?
You know, the challenge we have, of course, is writing a rule that covers businesses and organizations and facilities of all shapes and sizes. And you and I discussed that, and I think as a result of our discussion, you made a number of great suggestions that are in the current draft, in the rule that's been filed. We are certainly asking for support of this rule filed right now. Would you like to continue the conversation on kind of additional rules or changes? We are certainly very willing to do that as this epidemic evolves and as we hear feedback from businesses. We think as we're seeing numbers tick up now, it's a very critical moment, and it's important to have this in place. But in terms of ongoing discussion for the next step, I would be very happy to engage in that.
No, I appreciate that. And I think that's very important for us as legislators, as us as a co-equal branch of government, to be collaborating on these things going forward, because we do want to get this right. Let me get a couple of things on the record here so I can let other people speak as well. They have to do with a couple of things that aren't in the rule, maybe. One has to do with a question I got regarding families, communal families that are in a store together, and the 6-foot social distance requirement. Does that apply to them if they are family members, or then require masks in those situations? I guess that's the question I got, is how if a family walks into an establishment, they live together, therefore they're already communal. Are they required to social distance and/or wear a mask?
I think what we would ask to make it easier for businesses is that, the signage on the front says masks are required. The request is that customers wear masks even if they are part of a family. But obviously, if a mom responds back to an employee and says, look, we're all together, we're not planning on separating, we're not going to walk around without each other, I would not expect a business to have an argument over that. Okay.
Thank you. And then there's one other thing about the social distancing part of it. I think in other guidance that's been issued to date, there's a 50% occupancy or a 5 people per 1,000 square feet. This proposal doesn't include that framework for the 5 people per 1,000 square feet standard that, for instance, is in the Governor's Restore Illinois guidance.
Yes.
Is that standard being changed?
We got a lot of feedback on that potentially that standard was confusing. When you're looking at your business and trying to figure out, do all the square feet count? How does that work? And the recommendation as we reached out to organizations, was to stick with a more kind of across the board, 50 people or 50% or more of the capacity. Most businesses know their capacity pursuant to the fire code. That's an easier number to establish. And if that number is below 50, there's also a reference in this to the existing guidance and executive orders. That the guidance and executive orders are not meant to trump this, and certainly going forward, if those change, this rule will stay in place. It's a rule. It will trump that. But we tried to stick with clearer baselines. We thought that would be more helpful.
Okay, that leads me to actually my next question, so thank you for that. The question is, the rule states that it does not supersede any provision of an executive order or guidance issued pursuant to an executive order. So in effect, is this rule going to
Evolve?
well, it's going.
No.
I'm sure it's going to evolve. I agree. I hope it does at least. But the Elevance guidance over rule, which is in kind of a conflict to
Right.
the Illinois Administrative Procedures Act.
That is not what's intended. I agree with you that if it were read that way, which I do not think is what it's intended, we do not believe that a rule is overridden by an executive order or guidance.
Right, well,
This
yeah,
was-
that's my question. That goes to the
Correct.
idea that another part refers to it doesn't supersede any authority of an enforcing entity to enforce a local rule, ordinance, or order. But then, effectively, all the provisions of this emergency rule then could be overridden by a local ordinance by that, a reading in that direction.
What that was intended, and we have had this discussion now with a number of folks at the local level, was to say that to the extent there are local ordinance violations that are, or ordinances that are written and ordinance violations that are being enforced, we are not intending to replace those. Some of those are based on different facts and circumstances. They're addressing the COVID-19 pandemic. They are written differently. They come with a different approach, maybe a different fine level. And locals had contacted us to say, are you telling me we're kind of in the groove here? We have our law enforcement are used to enforcing our ordinance. Our ordinance is different. Can we continue enforcing our ordinance? And the answer to that is yes.
Okay, we may have to revisit this at some point in time about how that needs to be structured, just so everybody's in clarity on that part of it. And let me just go back, my last question has to do with going back to the reasonable efforts components of what we started talking about earlier. Walk me through why we don't have more specific guidance, or I shouldn't say not guidance, but that was overused in this case. But the things you outlined before, put a thing aside, asking people to wear masks, can't we just delineate those and put those right in the rule?
Well, we did put them in as an example in the context of retail businesses. Where we struggled, and based on the discussion that I had with you and Leader Cunningham, is how to write examples that cover all shapes and sizes of businesses and organizations, and how to not send a signal that was more confusing than helpful by trying to delineate too many examples. So we, at your request, put in the example related to retailers. The sense was that that was an easier example to tackle that would not risk causing more confusion.
Right.
If there are more examples going forward that you would like put in, we're happy to work on subsequent.
Okay.
It's not a desire to avoid examples. It's more a desire to be mindful that every shape and size, we don't want to start to get more confusing than helpful.
No, I appreciate that we were going to try and balance
Yes.
between the idea of what works and also then what is going to be read on the basis of a criminal penalty. And that's a very tough stuff, especially when we're talking about the Joint Committee on Administrative Rules, which is not a policy-making body, but rather a review and oversight body in this effector. So we're not here today to talk about whether or not masks are important, because I think we all agree that they have a role to play. It's certainly an important one. But rather how we implement what we're trying to accomplish here for the benefit of public health, at the same time balancing out all the elements that people have to try and comply with in a time when there are so many different things they hear from the CDC and the IDPH, and it changes over time. So it's very hard for a small business owner of the smallest variety to try and keep
Yes.
all the things are going on at the government levels, at the federal and state and local levels, and now there's a rule coming in that adds kind of a nebulous effect to that. I want people to be able to comply and know that they're complying and feel that they've done the right thing on behalf of their customers, their employees, their business, and the community. And I think we need to reach further to get that accomplished here, but I certainly appreciate what you've done so far to get that in here. So thank you. I'll let the next
Thank you
person.
very much.
Representative Tapati?
Thank you, Mr. Chairman. I do want to follow up with a couple of questions as well, and as the co-chair noted, that we are an oversight committee. That is what we do here, and I looked very specifically at the administrative code to make sure that, especially with an issue dealing with face coverings in the middle of a pandemic, that we're addressing it appropriately. And looking at the administrative code, at least section 21-200, talking about our function, and our function is to make sure that we cooperate with agencies. And looking at section 230-100, our basic policy is very specific as far as what's required to look at in the emergency rulemaking process. And my question is to the general counsel and also the other lady that's next to her, is that it says that the use of emergency rulemaking processes must be limited to situations that reasonably constitute a threat to the public interest, safety, or welfare, and that require the adoption of rules upon fewer days' notice than is required by Section 540 of the Act. Is that the case here?
Yes, we believe that is the case here.
All right, and then the administrative code moves us to look at the specific requirements that must be met and established as far as our review and the criteria that must be established. And I'm assuming that both of you ladies are familiar with Section 230.400, correct?
Correct.
And that's the section that lays out the criteria for review for emergency rules, correct?
Yes.
And then in section 240.400A1, there is a subsection dealing with emergency, and it lists different criteria from A through I, correct?
Yes.
Yes.
All right. And has the agency and or the rule satisfied all of these criteria?
We believe that it has. We have taken a careful look at the criteria in drafting the rule and before filing, and we believe it does.
All right. And then in section 2, dealing with substantive issues, there are subparts A and B there, correct?
Yes.
And does the rule and has the agency satisfied those criteria?
Yes. Again, we sat down after the initial drafting and went through these criteria to make sure they were met before filing.
And then, again, under section 230.400, under subparagraph 3, if you will, dealing with propriety, it lists 8A through F as far as criteria. Am I correct?
Yes, you are.
And does the rule and has the agency satisfied all of those criteria?
Yes.
All right. And then next, under proprietary, there's also a section dealing with procedural aspects, correct?
Yes.
And then that lists criteria A through C, correct?
Yes.
And has the rule or the agency satisfied all of those criteria?
Yes.
All right. So then at that point, under the administrative code, we would not be making any objections, we would not be making any recommendations, and we wouldn't do any further scrutiny and even consider a suspension. I do want to look and dig into the rule itself, now that we've established that. And in the rule itself, under section 690.290, all the way through to 690.800, we have several communicable diseases that have been enumerated there, correct?
Yes.
Would it be fair to say that the current SARS version of coronavirus that we're seeing now would be a new and novel virus that should be included on this list as well?
Yes, that's correct. In the view of the agency, the current COVID-19 presents with unique characteristics that require a separate approach.
So this is not just a normal SARS as is listed under this laundry list of different communicable diseases. This is something new and novel that you're addressing, correct?
Yes.
All right. And then I wanted to get some background quickly about prior actions that have been taken. And is there any precedence for this type of rule under the Communicable Disease Code?
Yes, there are several. As you noted when walking me through the sections of the Communicable Disease Code, you see that Jcar has approved and allowed the agency to take a disease-by-disease approach in the Communicable Disease Code. And that is supported by 690.100, which specifically says that the Department of Public Health, when dealing with an epidemic, if it determines that existing rules are not sufficient, shall enact and promulgate more stringent rules, which is essentially what you see embodied then throughout the current communicable disease code as it goes disease by disease to address specifics.
And as you mentioned, 69-100 actually lays out the method of reporting to be undertaken as well with respect to all of those different identified communicable diseases, correct?
That's correct.
All right. What is the department's authority to issue this rule consistent with the Illinois Administrative Procedures Act?
The department has would cite you to two statutes as authority. First and foremost is the Department of Public Health Powers and Duties Law, which is found at 20 ILCS 2310, and specifically Section 2310-195, which provides for the department to adopt all administrative rules that may be necessary for the effective administration, enforcement, and regulation of all matters for which the department has jurisdiction or responsibility. And to determine the jurisdiction and responsibility of the Department of Public Health in keeping with that provision, we would look to the Department of Public Health Act, 20 ILCS 2305, which in Section 2A authorizes the department to investigate and take means to restrict communicable diseases and to have general supervision of the health of the people of the state. Those two together, we believe, authorize these rules.
Now, again, in this committee, we look at, emergency rules and normal rulemaking and the process as we're reviewing them. But what authority to issue this emergency rule rather than a regular rulemaking does the agency have?
We believe the agency has emergency rulemaking authority, which is noted in the Administrative Procedure Act, as well as the Department of Public Health Act. We believe the current situation, as we are now in several months into COVID-19, and we see, unfortunately, that our current measures are not sufficiently continuing to bend the curve, but we are seeing an uptick in numbers that is very worrisome. We believe this situation presents an emergency.
Thank you for that clarification. I know that we touched upon this issue the last time that we were all in Springfield, and I'm referring to the General Assembly, and we did have some discussions about this rulemaking at that time. Are you aware of any proposed legislation that has been presented to you, and I'm referring to the agency, the Department of Public Health, and or the Governor's Office, from the business community to address this issue that's been out there since May?
I am not.
Thank you very much.
Thank you.
I don't have anything further, Mr. Chairman.
Thank you. Representative Halpin.
Thank you, Mr. Chairman, and thank you, Ann, for being here. Representative Petty covered some of the basics that I was going to cover, but I did want to ask, as a follow-up regarding Section 2A of the Department of Public Health Act, there is a provision in there that refers to neglect or refusal of local public health bodies to act. What is your or the department's position on whether a specific finding needs to be made or whether that applies or does not apply?
I do not think a specific finding needs to be made or that applies. As I read that paragraph, it's a separate paragraph in Section 2A, kind of midway down. There are two clauses. The first being the Department of Public Health shall investigate the causes of dangerously contagious or infectious diseases, especially when existing in epidemic form, and take means to restrict and suppress the same. We think that clause is what applies here. The paragraph then goes on to say whenever such disease becomes or threatens to become epidemic, and then goes on with several clauses to identify a scenario where a local public health department has neglected to take action. And that, we believe those clauses, what they lead into is the rare instance when the Department of Public Health can charge a local public health department for its actions. That charging ability is limited by those clauses. The overarching ability in the first clause is not limited.
Okay. I also wanted to ask a little bit more about the practical application. I believe Representative Wheeler did go through some of the questions I had. But what steps, if any, has the department taken in preparing this rule to reduce the impact on small business in particular?
I think that the most important steps that you see written into the rule, and these frankly came from a lot of our conversations, in particular with leaders Wheeler and Cunningham. We made a number of these, I think, important changes. But the concept of reasonable efforts, and where it specifically refers to taking into account the totality of the circumstances, in my view, a lot of that was focused specifically on addressing the fact that businesses are present in very, very different ways. You may have a 7-Eleven with one employee, where it is not reasonable to expect that employee to get out from behind the cash register in the booth that they're in and go talk to the customer and engage with them on wearing a mask. That is a totality of the circumstances fact that I think is critical to be considered, very different than the Home Depot, where putting up signage and perhaps kind of regulating the number of people coming in and out is more reasonable given the staffing. So the goal in giving the example, as well as putting in phrases like totality of the circumstances, was to bear in mind at all times that we have businesses that are very small and will struggle. I think the concept of giving a written notice is also critical in order to inform the manager, the business owner, what are we looking at that causes concern. Give that person a real written understanding so that it's not a gotcha. It is an opportunity to review. I think giving time to come into compliance, and that time is also based on the circumstances, I think that time is going to be driven in part by the size of the business, the staffing, the ability for them to perhaps change the condition that's being identified. All of those things, in my view, will require consideration of the business's resources and size.
And the intent, again, is not to penalize businesses just because a customer isn't complying, is that right?
Yes, the intent very specifically, part of the reasonable efforts was driven, I think it was Leader Wheeler who pointed out on a call that in an earlier draft it was written where it could have been conceivable that reading it, we gave the impression that the business was expected to achieve 100% success, which is of course not remotely realistic. And so the focus with the language that was added in several different sections was to make it clear that the business can only control their own reasonable efforts. There will be customers who will not comply. As we talked earlier, there are lots of reasons why a business would not be able to overcome that reluctance of a customer, nor would be expected to. And so 100% success is not expected by the business.
And really where the department's goal is to enforce, I guess for lack of a better term, businesses that are complicit in maybe looking the other way about a mask requirement or consciously supporting large gatherings of people without maintaining social distance and wearing a mask. Is that correct?
That is correct. We have worked closely with the Attorney General's office as they've received complaints about businesses, and one thing has become clear is that businesses themselves, bar owners, for instance, restaurant owners, have expressed tremendous frustration when they are following the rules. They are limiting the number of customers that they have. They are limiting the amount of people that they're serving over the course of the day, and another bar or restaurant down the street is not. And so part of what's driving this rule is to try to level the playing field so that businesses that are doing their best to deal with a very difficult situation are not disadvantaged.
There's also been some worry that a prosecutor or a local health official would be able to or would not be able to limit any ultimate misdemeanor or anything like that to an individual. The way I read the rules is that if you are an individual, it is not possible for you to violate DPH rules and subject you to that. Is that a correct reading? Is that the intent of the department?
That is the intent of the department, to place the responsibility for compliance on the entity level such that it's not a violation based just on the conduct of an individual. That is correct.
Okay. Well, I do want to say that when this rule first was proposed back in May, I had very significant concerns with it. But I do appreciate the department coming back and engaging both with me and other members of Jcar, as well as some of the folks that do have some objections. Can you describe, can you go into detail about what those efforts were and how you intend to proceed going forward as far as implementing these and any other changes you may have?
As you have identified, Representative, we had conversations with a number of members of Jcar. I'm not sure that we spoke to all of you, but we endeavored to speak to as many people as we could. We also, through the outreach side of the governor's office and of DPH, spoke to a number of organizations and business owners. That is obviously ongoing. Our next step, what we have done throughout the pandemic, is to ask State Police Director Kelly, for instance, to reach out. He has hosted numerous calls with police chiefs and sheriffs around the state to talk through and literally get to the point of talking through hypotheticals and about enforcement and hearing their concerns and working on, is there guidance that he could be pushing out? And I don't mean guidance in an official sense, but offering thoughts and recommendations and bringing people together. That will certainly happen about this. We will continue outreach. The department does significant outreach to local public health departments to offer them input and guidance on what is intended by the rule and also to answer their questions. And there is an ongoing effort between Department of Labor, the Governor's Office, the Attorney General's Office to have weekly enforcement conversations where we talk very specifically through hypotheticals as well as concrete situations about what should the answer be to a business that's calling, maybe they're calling DCEO, maybe they're calling the Attorney General's Office with a question. And so we have shared these rules with that group, and we'll be beginning now, we began last week, an ongoing conversation about how to give guidance and how to answer questions so that in an attempt for the state government level at least to be providing the same information to police chiefs, to sheriffs, to businesses, to business associations as much as we can.
And I guess lastly, is it the department's understanding, or at least I should say, maybe it's not a question, but again, a comment. I hope that the department is understanding that if this rule does, go through today, and we see enforcement that doesn't follow the intent, I mean, do we have a commitment from the Department of Public Health to change the rule as necessary, or possibly risk a different decision from this committee?
Certainly, you have a commitment.
Yes.
My colleague can speak for the department, certainly a commitment from the governor's office to continue this discussion. As you are seeing different circumstances in your communities and questions arise, we are happy to be on the other end of the phone to have this conversation.
Thank you so much. Thank you, Mr. Chair.
Senator Resin?
Thank you. I appreciate it. So it is not your intent to punish. However, is it currently, though, in statute? We've heard a lot of legalese here today. I'm not an attorney, but I received the phone calls from small businesses who are still concerned that in statute, it still states that this is punishable. It's a Class A misdemeanor, punishable by up to $2,500 fine and up to 1 year in prison, correct? Now, I know that we've had the conversation because it is not your intent to, as you have stated numerous times today, to apply this punishment to individuals. However, this is a rule, right? And we've had the discussion regarding what will take precedence, the statute, which is very specific, or this rule in which you state that it is not your intent. And that's the challenge that we are having here today. My question to you is that you mentioned that you do not want to punish individuals. The phone calls that we receive are from small companies stating, well, I get it. You're stating that you only want to come after the businesses, but the businesses are owned by LLCs, by individuals, by sole proprietorships. What does that mean to that person who has the hair salon, the nail salon, a small business? Can you walk me through that process and tell me how the person who owns that company, that small business, will not, the intent is or is not to hold them accountable?
Well, thank you for asking that. I don't think, while I have expressed my intent in answer to a number of questions, I don't think you have to go by my intent. I think the language of the rule, and this is frankly something that evolved over the course of working with members of this committee. The language of the rule is focused on creating a violation. The rule itself only places an obligation on the business level. It is written to say the only way to violate this rule is at the business level. So I know that Senator Kern and I have had kind of a debate going back and forth about this, and I think we're going to end up in an agree to disagree moment on this. So I feel that's coming.
Probably, I'm guessing.
I don't know why. But I think it is now written as clearly as it can be, and I believe it is written effectively, to place the obligation clearly at the entity level, so that an individual cannot violate the rule. They can't be prosecuted because they didn't violate anything. So my intent is helpful, but my intent is not what you have to go by. It is written into this. I think it would take a state's attorney absolutely and completely ignoring the language of the rule, which I have no indication that any state's attorney in this state is so anxious to enforce these requirements that they're going to completely ignore the language of the rule.
But correct me if I'm wrong, the state's attorney is not the only person with authority in this role to assess a penalty. So it's the state's attorneys, who else
The
has the power?
state's attorney is the only person in this state charged to enforce a
Okay, so
misdemeanor.
Department of Public Health,
No.
they do not have power to come in, authority to come in and cite somebody or a business?
The misdemeanor penalty can only be enforced by a state's attorney.
Enforced,
Through a
okay, well,
court.
let's back up then. So who has the authority to come in before it gets to the state's attorney and to cite a business?
The authority to go through the step-by-step enforcement process comes from the statute and existing rules, which provide that public health rules, so you see it here in D, and the reason the language is in italics in D is that that comes from the statute. We did not expand. All public health rules can be enforced by local boards of health, health authorities and officers, police officers, sheriffs, and other officers of the state. So in terms of who can go into the business and begin the discussion that is the step-by-step progressive process, that can be done by public health authorities at the local level, public health authorities at the state level, or all law enforcement. But once you get to the point of saying, I think we've gone through these steps and we're now at the misdemeanor point, that requires a law enforcement officer and ultimately a state's attorney and a court. The public health department can ask local law enforcement to write the citation for the misdemeanor. They can ask the state's attorney to prosecute that misdemeanor, but that is entirely in the discretion of the state's attorney.
So let's talk just briefly about the state's attorney. You mentioned the state's attorneys probably will not do that, but there might be a state's attorney out there that's trying to make a name for himself. I don't know. And they choose to then go after a business that has been practicing poor behavior, not social distancing, not wearing masks. Can you go through the process then that the business would have to go through with that state's attorney?
The way that a misdemeanor citation works for a business and even for an individual is a law enforcement officer would issue a citation. There's no one is taken into custody. There's no, even if it wasn't, frankly, a business at the business level, which ensures that no one is taken into custody. Individuals are typically not taken into custody. Again, this doesn't apply to individuals. That citation would give probably a date to appear, which may be in many instances 90 days later. It's a date to appear in court. Often at that stage, you see in misdemeanors there is a negotiation. That's up to the state's attorney. But if it goes forward all the way to an appearance in court, it would then be an appearance in front of a judge to determine whether there needs to be a trial on a misdemeanor or whether there will be a resolution short of enforcing the misdemeanor. So it's a citation. As I understand it, law enforcement officers generally have kind of blank misdemeanor citation forms. The clerk of courts lists all of the possible misdemeanor citations, and Public Health Act 8.1 is listed as one of them. It always has been, and that's what would be cited.
Okay, thank you. It's been talked about briefly before we came in here too, that the Department of Public Health has always had that authority for different scenarios. But again, I think we can all agree that we're in unprecedented times, everything that we're talking about here. So even though they've had that authority in the past and most likely have never used it, again, we are in extraordinary situation where we're discussing scenarios that we never thought we would be discussing. Let's talk briefly about several counties that have been put on a warning list, which we all know. I have one in my district as well. Once a county goes on a warning list, we received reasons that county, which is very helpful, was put on the warning list. And I looked at all of the different reasons for the different counties, and more often than not, I would say one of the main reasons is our large group gatherings. How does this emergency rule apply to large group gatherings?
I think similar to a gathering inside a bar, a large group gathering that's not in a business but is occurring, in the park, not social distancing. I mean, many of us who read the Chicago papers.
On the beach.
Watched as, right, Mayor Lightfoot took matters into her own hands. I think this rule gives local health departments as well as local law enforcement, if they don't have ordinance violations, and many do, the authority to comfortably go up to a group that is over 50 people or they're not social distancing, they're not wearing face coverings, and again, ask them to move along. There is no ability, and when you're talking about a large group that's not connected to an entity, there is no ability to cite them with the misdemeanor in this rule.
Okay.
But it does provide helpful, through the early months of this epidemic, if Director Kelly were sitting here from the state police, what he would say is he struggled in talking to law enforcement, talking to his own troopers and in talking to law enforcement across the state. He struggled to be able to point them to a rule that they could enforce, even if it didn't mean there was no desire to write tickets to people. There was no desire to arrest people, but even just to be able to point to something to say, other than an executive order, to say you really have to move along. You have to break this up. This is a public health danger. Come on, people, let's separate here. He felt strongly that just having a rule to do would provide an extra oomph and an ability for an officer to feel comfortable that they really are enforcing something. But there is no penalty for a gathering.
For a large gathering.
That's correct.
Okay, thank you. And in closing, my colleague talked and asked you a question before about businesses and the fact that they haven't brought you language, I guess, to address this issue. I look back on the time frame that when this initial discussion started, which was the middle of May, and when the first rule was brought to us. And granted, where you were with the first rule and where you are now is, this is much better. So we do appreciate you taking into consideration many of our concerns. So thank you for that. But, let's be fair here. We knew we hadn't even bent the curve at that point, that numbers were still going high. It was a huge emergency concern back in May. We're in session till the end of May, but yet there was no, the legislative fix is a legislative fix. There was no legislation that was brought where we could vet and even put more kind of what-ifs into that legislation to deal with the pandemic. So, I do think it's unfair to say, why didn't the businesses bring us that legislation? It's not, our opinion is, it's not their job. So my question to you is, and it's a fair question, why didn't the administration bring legislation to the legislature who was meeting at the end of May so we wouldn't have to go through the administrative rule process?
I think the best answer I can give you is that when you look at the Communicable Diseases Code, it is through the code that public health has dealt disease by disease. This is the standard operating procedure for dealing with specific diseases. So I understand the frustration about not having legislation. Ultimately, that's above my pay grade, but I believe that this is, when you see over and over again, it is the rule mechanism that has been used for specific diseases. We are in a different situation now in the sense that the response to COVID-19, not because of this committee, and frankly not even necessarily in Illinois, has become very politicized. But the putting that politicization aside, it is very clear that the code, the Communicable Disease Code, has been the mechanism for decades in this state to deal with specific disease outbreaks and address them. And there are some pretty draconian requirements in that code when you consider the 8.1 misdemeanor. So I think we, as we looked more closely at it, felt comfortable, again, there may be disagreement, that the rule approach was what was expected for dealing on a disease-by-disease basis.
Thank you.
Senator Schimm?
Thank you, Mr. Chairman. Thank you, Ms. Spillane, Ms. Olson, for coming in here to testify. And I do want to echo what some of my colleagues have already said about how commendable it is that you all have reached out to us and that we've had a dialogue. That's in contrast to what happened in May. That's water under the bridge. But I do honestly appreciate the fact that we have been talking and that Governor Pritzker and his administration are trying to receive the input of the General Assembly. So thank you so much for that. Ms. Olson, I think since you're being left out, I just want to start with something quick for you, and then Ms. Spillane will you can get a drink of water or catch your breath. But just really quickly, in Section E of your rule, it's talking about when there's an investigation that is required. So this is towards the very end. Towards the bottom of that paragraph, it just talks about when 2 or more suspected cases of COVID-19 occur in any business, organization, institution, facility, school, or daycare. But there doesn't seem to be any type of cross-reference to the size of the organization or the school. And I just wondered, if you could kind of explain to me what the thinking was to just seize on the number 2 rather than, set up a percentage. Because obviously, it's much different if you have a small school, that maybe has, 200 students, has 2 cases, as opposed to one of these, large suburban schools that maybe has 3,000 and only has 2 cases. So kind of explain that rationale to me about that.
Sure. So during the COVID-19 pandemic response, 2 cases has traditionally been a trigger for the department to start investigating a potential outbreak. And so outbreak is defined in the Communicable Disease Code as occurrence of an illness, in this case COVID-19, in a person or a group of epidemiologically associated persons with a rate or frequency clearly in excess of normal expectations. So this morning I reached out to one of my colleagues and I said, what does this mean? What is a normal expectation? And the normal expectation should be that COVID-19 is not present, so it should be 0. And so at 2 cases, we have an indication that COVID-19 may be spreading or may be present. And that is why this rule is written such that you shall cooperate with public health authorities in the investigation to determine whether or not COVID-19 transmission within that community is spreading.
Is there any significance to, I'm a patent attorney, and sometimes, you have words like obvious or something like that have a special significance that the public wouldn't otherwise know. Is there certain triggers that occur when you say they have to cooperate with an investigation? Is there anything that is kind of behind that terminology that we need to know about?
I would say cooperation, it has its plain sense meaning in terms of if I were to come in and ask you if you have records of who is on your premises, let's say your business is such that it's easy to identify who is at your business, that a cooperation would be that you provide that list and contact those people and tell them that there was a positive case, encourage them to get tested. Cooperation would include potentially cleaning or disinfecting the area appropriately. Cooperation does not have a trick meaning or a special meaning in this context.
So just to be clear, so to put it on the record, that's not going to be a case where if there are two cases in a school, that's going to lead the school to have to close. That is not the intention. Okay. I think that it would be factual based on the school and the size and what's going on at that particular school. Okay.
And I would add just to the sentences in E that you're focused on are taken from other sections of the administrative code, so we're not paving new ground. The two or more appears in, I think it's 690-30A5, so that is the normal trigger for investigation of a communicable disease. So
Okay.
we did not want to pave new ground in this section. Outbreak, which is what would trigger a potential closure, and closure has to follow all the existing due process. Outbreak is a fact-specific, as it's defined, as my
Okay.
colleague mentioned, and would definitely take into account size. So your point of, you're talking about a huge school versus a tiny, outbreak takes into account fact-specific as well as disease-specific factors.
Okay. And then, so we've been working with iterations of this rule. There was a previous iteration of this rule that was going to require facility closure whenever there were
Correct.
two.
And that was changed
And that
at the
was
request of
taken.
members.
Okay,
Yes.
so that's,
Yeah. Yes.
that's not operative. Okay.
Correct, and we went back then, based on commentary, which was very helpful, and I think identified a flag of a problem, we changed, and so the information you see in E comes from other sections of the administrative code.
Okay. No, so I was going to try to give you a chance to catch your breath. So, okay.
Welcome to
You're a glutton for punishment, Ann. Okay. All right. So I think it's already been asked and answered, but just to make sure I understand this, the authority for this rule, you said it comes from two different pieces of statute. And the second one that you cited was this Department of Public Health Act, correct?
Well, the reason I went to that is because the first authority is in the Health Powers and Duties Law, where it says the authority to promulgate rules for all matters for which the department has jurisdiction or responsibility. And then to determine the department's jurisdiction or responsibility, I looked to the Department of Public Health Act, 20 ILCS 2305.
And when you talked about that with my friend Representative Tapetti, I thought you said something about that. I thought you mentioned that there was a source of authority. You were saying Rule 690.1.
No, I was not citing a rule as
Okay,
authority.
because that's what I was going to.
Nope.
That's what I was going to say. We can't.
No, I understand that. What I was saying was that to give you comfort that there is authority for this, you can look to the existing rules in the Communicable Disease Code, which clearly contemplate a disease-by-disease approach. They are not authority. They simply tell you that Jcar has, over decades, found authority for the Department of Public Health to issue rules on a disease-by-disease basis. And 690-100 is I think, the best example, because it says that the Department of Public Health, in an epidemic, if it determines its existing rules are not sufficient, shall promulgate more stringent ones. That's not authority to promulgate a rule. I think that's more of an example of what has been contemplated by Jcar as it looks at public health rules.
And one of the things we talked about that in our in some of our internal discussions beforehand, but some of these Department of Health rules may in fact predate the Illinois Administrative Procedures Act. So, to say automatically that because there is a rule in place means that it's okay, I don't necessarily find that tremendously persuasive authority. I understand the point that you're trying to make, but those rules could have been put in place prior to the Illinois Administrative Procedures Act, and they may not have been appropriate, or they may not have passed the level of review that we're looking at them at, correct? So and to go back to what I started off by saying, I'm a cards on the table kind of person. I always have been, and when we were talking about this rule and the discussions that we've had, I really laid out for you, what my skepticism was. And when I talked to the governor this morning, I said, Governor, I'm not a hard no. I'm very skeptical, because I don't think that this rule really aligns with what we have in statute right now. And you've done a very good job of citing stuff that is in 20 ILCS 23-05, all the verbiage that is in there, you have in fact cited. But if you look at that statute, the thing that you haven't mentioned in your testimony yet is there is a section C to that statute. And really throughout this entire statute, I didn't take the time to go through and count how many times it says in here, subject to the provisions of subsection C, as the enforcement mechanism. It's probably about 10 different times. The way the statute is written, it gives the department the power to, the power to try to enforce all this stuff and take actions, but it specifies a specific enforcement mechanism that the department is supposed to use. So my question that I'd like to give you a chance to respond to now, and it's the one that I asked during our phone conversation, is what authority within this act gives the department the ability to set up an enforcement mechanism independent of what is already in the act in section C?
I do not believe this. First of all, I think that what you're seeing is consistent with the approach the department has taken in administrative rules dealing with specific diseases. What you see throughout the Communicable Disease Code is specific requirements, disease by disease, that are separate from isolation, quarantine, and closure. There are two, so the department tends to take, there are parallel tracks here. One is, what are the requirements disease by disease? So for instance, you see mumps, measles, whooping cough, very specific requirements, including that if you are a suspected case, you must be excluded from work for 12 to 25 days. That comes with a misdemeanor violation. Those are consistently throughout the Communicable Disease Code. There is also, separately, the isolation, quarantine, and closure rules and all of the due process that comes with that. We are not in any way tinkering with isolation, quarantine, or closure. The department could still pursue those, and they would have to meet all of the requirements that are set out in existing law and rules, including if it does not become a voluntary quarantine or a voluntary closure, court hearing within 48 hours, proof by clear and convincing evidence by the department. So I don't see, if you look at the existing code and the existing statute, I do not see that this is an attempt to get around isolation, quarantine, or closure. This is a separate enforcement that is allowed and is carried out throughout the Communicable Disease Code.
Okay. Well, I think this may be one of the instances where you and I agree to disagree.
I understand.
But my reading is that according to the statute, and we may say, you know what, we think the statute needs to be updated. That's a perfectly, in my mind, defensible position. But I don't think that's the role of this committee. The last thing that I'd like to talk to you about is the piece of the rule that says, and this has been touched on already, that it's not going to apply to individuals. It's only going to be applied to businesses. And I'm not arguing about whether or not that is a good point or bad point. What I have a problem with is an administrative agency taking a statutory provision, a statutory penalty, and deciding that statutory penalty is only going to apply to one, to one group and not apply to another. What's the authority for the rule to be able to do that in administrative law?
Mm-hmm. This is where I think we do have a disagreement, and again, Senator Kern's going to weigh in at some point probably, unless everybody else is covering it for you. I would argue that we are not saying, here's a violation that everybody engages in, that you individually are violating this, and then I'm saying enforcement can't enforce it. I think that the rule is drafted and I understand there's going to be disagreement here, I think the rule is drafted to say the only way to violate it, the rule places its obligation on the entity level. And so the only violation that can occur is at the entity level. I understand. I can see the look of incredulity.
I don't have a very good poker face.
So,
I
no,
apologize. Even with the mask.
Even with a mask. So I think there's some disagreement here, but I believe that we, over the course of discussions with the committee, have clarified, and I do think this is appropriate for the administrative agency to say, here's what we're asking be done to comply. And then a failure to comply is by the entity being asked to comply. That's how I would approach this. I think that is permissible for the agency to do. I do not think this is a situation where we are saying an individual is violating this and we're ordering that we're narrowing the misdemeanor.
It seems like what you're doing is saying that according to the mechanics that we've set up, an individual wouldn't be liable. The concern that I have is not from a policy standpoint. Mm-hmm. It's from the prerogatives of the legislature. Mm-hmm. We have tons of laws where the legislature has set penalties, some criminal, some civil. But I mean, is it your position that an administration could, like, say, take the penalties associated with the Illinois Human Rights Act, that an administration could take those penalties and say, well, they're just not going to apply to a certain class of defendants? Do you think that's sound administratively, that an administration should have the ability to do that?
I don't think that, but we're a little bit talking past each other. And so you're saying that, and I'm saying something different. So this is, again, I feel pretty certain going to fall into the agree to disagree category. But what I'm saying is that you have a statute that says every violation of a DPH rule is a misdemeanor. It doesn't say DPH has to draft rules in a specific way. It just, every violation of a DPH rule is a misdemeanor. What I'm saying is DPH can then draft a rule to say, based on this disease, in this situation, we are drafting a rule to say the following entities are responsible for doing X, Y, and Z. And that's what they've done here, and I think that's acceptable. I think we're kind of, talking past each other at a certain point.
And I know that, that you've probably looked at the appellate court rulings on this issue. Do you think your view is consistent with what the appellate courts have found in the state of Illinois?
I do, yes. Okay.
No, I do appreciate those. I appreciate the candidness of the responses and the conversations that we've had. I want to thank my fellow committee members for their indulgence. I've talked a lot. I just want to close by saying, this is a procedure committee, not a policy committee. The job of this committee is not to decide whether or not this is sound policy. The job of this committee is to decide whether or not this proposal complies with the Illinois Administrative Procedures Act and doesn't run afoul of statutory intent. Mm-hmm. To me, this is a clear case where I don't think it matches up with the statute that's in place, either on the penalty provisions or on the enforcement provisions. And I think because of that, the solution should be to call a special session and fix the legislation. And I had this discussion with Governor Pritzker this morning. He doesn't think it's practicable to call a special session. I respectfully disagree with him. But I've heard a lot of talk about how we have to do something to make it more likely that Illinoisans are going to comply with the mask mandate. Honestly, having talked with some of the Illinoisans who refuse to wear masks, passing this administrative rule is not going to make people more likely to wear a mask. What is going to make people more likely to wear a mask is if the governor says, you know what, this really is an emergency. This is something that is appropriate for a special session, and then if you have a mask mandate that is put in place subject to the legislative process that has the full support of the rule of law, then I believe people will take this much more seriously. So thank you for Thank you for answering my questions. Thank you, Mr. Chairman.
Thank you, Senator
Thank
Kern.
you, sir.
Thank you, Mr. Chairman. General Counsel Spillane, one, I want to echo a lot of what you've heard already this afternoon, which is I'm very complimentary of not only the time and your availability in working collaboratively and providing insight on this rule to myself, but also other committee members, but the governor's entire team. It has been a real collaborative approach, which is, refreshing and a much better tack than was taken in May. And I think you got to a better product by doing that. And I just want to thank you and thank everyone part of the governor's staff that participated in that. So I really appreciated that. I'm going to try to be succinct because some of my colleagues have covered the point, the issue I have with this rule. I want to go back to your discussion with Senator Rezin on Director Kelly and his desire to have something in a rule to point to groups, individuals that were not social distancing. Do you recall that discussion?
Yes, I do.
Okay. So the director wanted something in the rule to point to so he could go up to a group and ask them to go along, to comply, to socially distance in a responsible manner, which we should endeavor, all of us as Illinoisans endeavor to do. That is what you're referring to C1 in this rule, is that correct? Any individual who is over the age of 2 and able to medically tolerate a face covering shall be required to cover their nose and mouth with a face covering when in a public place and unable to maintain at least a 6-foot social distance. This requirement applies whether in an indoor space such as a store or in an outdoor space. That would be one of the directives that the state police director or another law enforcement officer could point to. Would that be?
I think I was referring more in the exchange with Senator Rezin to C4, which was just a discussion of gatherings of people, but you're correct. I think they kind of go together.
C1 or C4. C4 goes to the limitation of 50 people or less in a gathering.
Correct.
And if I go back to your discussion with Representative Halpin, and I'm not sure whether it was Representative Halpin or yourself, but one of you said it's not possible for an individual to violate this rule. And I think that may be where the problem exists, in my view, on this rule, because that seems to be a contradiction to C1 and C4, which is a directive or a mandate clearly placed on individuals, not on businesses, in this rule as written. And so when I look at the statute, in applying that directive, Section 8.1 says, and this is not in the rule but in the statute, whoever violates or refuses to obey any rule or regulation of the Department of Public Health shall be deemed guilty of a Class A misdemeanor. Further along, it states, each state's attorney shall prosecute all persons in his county violating or refusing to obey the rules and regulations of the Department of Public Health. I see a state's attorney well within their authority to prosecute an individual that doesn't comply with C1 or C4. I know we disagree, and I want to be fair. I would like for you to put on the record why that is not possible, why a state's attorney would not be authorized to pursue that prosecution.
I believe, as I have said in response to your colleagues, that the rule is written very clearly to state that the actual obligation for compliance with it lies at the entity level and not at the individual level. So definitely you and I disagree on this point, but I believe a state's attorney would have to look beyond that, and I think they'd have to disregard a significant chunk of the rule in order to forge ahead.
I do agree with you that you have written that point and intent in this rule as clearly as you can. I think there's just a fundamental flaw in the rule itself based upon the statutory language that it's obligated to in 8.1. And then my last point that I'm going to turn to is an appellate court decision. There are several out there, but Illinois RSA number 3 Inc. versus Department of Central Management Services. So this involved the state. The background is a wireless telephone company sued the state claiming the administrative rule limiting reimbursement of 911 service costs to 100% of surcharges collected was violative of the statute when the statute specifically limited the reimbursement of surcharges to 125%. So they set a ceiling in statute, and the agency came in and tried to lower that ceiling, which was not on par with with the statute. And the appellate court held that the agency lacked discretion to make a blanket rule limiting reimbursement below level set in the enabling statute. It further went on to state that an administrative rule is invalid if it conflicts with the language of the statute under which the rule was adopted. To determine whether an administrative rule conflicts with its enabling act, the court should ascertain and give effect to the intent of the legislature. While administrative rules interpreting a statute serve as guidance to legislative intent, the rules are binding on the court only to the extent that they follow the statute. Administrative rules can neither limit, enlarge, nor amend the scope of the statute beyond the clear import of the legislative language used. When I look at the clear language of 8.1 and turning back to that, I don't find this to be ambiguous at all when it states each state's attorney shall prosecute all persons in his county violating or refusing to obey the rules and regulations of the Department of Public Health. And that is, as I read before, deemed guilty of a Class A misdemeanor. I don't think there's anything prohibiting the state's attorney from prosecuting someone under C1 or C4 in this rule. I realize you've done the best you can, and I'm very complimentary of how far you've gotten this rule. I just think you've run into a limitation in the statute, and the only cure for that is an actual amendment to the statute, which would be the proper fix that would be clear, and there would certainly be no uncertainty out there whether or not this could be applied. So I respectfully, as you say, agree to disagree, and I thank you for your approach on this.
Well, thank you very much. I should say thank you to all of you again. The conversations that we have made a lot of changes to the rule. I recognize not as many as some of you would have liked, but I do believe it has become a better product, and I appreciate all of your time.
Representative Reich?
Thank you, Mr. Chairman, and thank you. You've done a great job of defending your rule, and and you've done no, not yet. The thing, first, I'm going to throw you a softball. Define gathering, please.
I think it would be, I'd have to pull up the dictionary. I think it would be its dictionary definition is where you'd go first in a court. If I were writing a brief to define gathering, I'd go to the dictionary.
So a gathering does not constitute the people walking around a Home Depot in various,
Correct.
Gathering is what happened on the beach in Chicago.
Yes, correct. I would look to the dictionary definition. It is not a defined term as we searched, and it is not defined in relevant statutes or rules.
Very good. Okay. We've gone through the individual exemption and all this kind of stuff, but the section provides, section 650 D1C provides, no individual may be subject to the penalties set forth in section 8.1. Okay. Is this rule providing an exemption from penalties under the Act of Section 2305, specifically including individuals, individual owner, officer, principal, or employee for business? Is it providing an exemption to those people? Is that what you're doing here?
I think we're saying that the obligation to comply falls at the entity level, not at the individual level.
Where are those exemptions in statute?
that again, we're saying in rule that the actual definition of a violation is at the entity level.
If that's the case, then where in section 8.1 does it say that violations of this rule imposing misdemeanor penalties applies only to a business? Where does it say that?
Again, you and I are now talking past each other in the same way that I did with two of your colleagues. So
Okay, very good.
Watch this movie again, but
Okay. I'm going to read to you section 5.5, accountability for conduct of corporation under section 720 ILCS 5. A person is legally accountable for the conduct which is the element of an offense and which, in the name or in behalf of a corporation, he performs or causes to be performed to the same extent as if the conduct were performed in his name or on his own behalf. This is out of the criminal code. How do you square the exemption of individual liability with for people who are, who act on behalf of a corporation, with a clear injunction in the criminal code to hold people, individuals, persons, responsible for the action of the company?
again, I see this as not as an exemption, but as the Department of Public Health identifying what a violation means in writing the rule. So I'm approaching it from the different side, and I understand there's a...
I understand the position you're bringing it from, and I don't think you have any alternative in this case, because I do believe that this rule, in its current form, and frankly speaking, it's light years from where it was in May, still does not provide the kind of assurances. Basically, what you're doing is you're pulling back on statute. You're making statute less than what it actually is. You know, these statutes were provided for by the legislature. They were debated. They were voted upon. These statutes represent the will of the people of Illinois. Your rule basically takes that statute and says, we're not going to follow this portion of the statute because it may be inconvenient to do it, or it may be impossible to do it. But the simple fact is, in my mind, that we're still doing this to limit the reach of the will of the people of Illinois, which they enacted through statute. And I guess I'm going to close by saying, I'm not sure that this pandemic is over. I mean, history tells us that there's a second wave coming, and it could be a lot worse. What are we going to do if we shoot every arrow in our quiver now to address phase one, where we're doing this kind of thing, when we may end up with a governor having to issue, or feeling like he has to issue, an executive order locking people in their homes? I'm not saying that's going to happen, but the simple, we saw it in Hong Kong, people in China, people were welded into their homes. This isn't 1918 yet, but I want to make sure that if we have the kind of reaction, or this virus does what it did back 100 years ago, that we still have some bullets left in our gun, that we have the tools to be able to say, this is where we need to go. And I do believe that the governor is trying to do something that he would gain the cooperation of the legislature if he were just but to act and send us back in session. So as much as I would like to say, yes, I can support, I fully understand, and I don't disagree with what you're trying to do here. It's just not the way it should be done. It should be done through the legislative process, and unfortunately, as good a job as you've done to bring this thing as close to possible, I just can't support it. I'm sorry. Thank you.
I understand. I appreciate your viewpoint.
Okay, I think my co-chair, I'm sorry, Okay, I think my co-chair, Representative Wheeler, had some comment to add, and then I think we will entertain a motion. Representative Wheeler?
Thank you, Mr. Chairman. Again, thank you both for your indulgence today. I know this has been a long process to sit through, and I wish that many of the things you've said today that explain or defend the way the rule is constructed were actually in the rule so people could read and understand it more clearly. What we're left with today is what we have to address the rule the way it's written. And there's a part I just want to refer back to the Illinois Administrative Procedure Act regarding implementing discretionary powers. And each rule that implements a discretionary power to be exercised by an agency shall include the standards by which the agency shall exercise the power. And those standards shall be stated as precisely and clearly as practicable under the conditions to inform fully those persons affected. And I don't think we achieved that in the draft of the rule that has been filed. Now, with that said, I really want to take you up on the discussion we had earlier about continuing that discussion going forward to try and achieve something that I think would be more universally accepted and give businesses specifically and all those organizations affected a chance to know that they're complying with the intent in order to be able to achieve better public health and safety for their customers, their employees, and the community as a whole. So, again, I want to say thank you and look forward to further discussions regarding that. Thank you.
Thank you.
Okay, I too want to join in the chorus of the members thanking the Governor's General Counsel and the department for all the work you've done on this. I think it's really important we take a step back and remember where we were in May when this proposal first surfaced. And there was a lot of discomfort with that proposal universally in this committee. And that was largely because of a provision that would allow for the jailing of an individual if they violated the rule. That was the main point of objection. I want to thank the administration and the department for removing that from the rule as it stands right now. Now, we've heard some dissection on how you've done that. I understand those questions are complicated legal questions, but it is part of a good faith effort by the department to ensure individuals are not arrested and do not face jail time for not following these provisions. And I think that you've handled it in an appropriate way. I also think another crucial change that needs to be highlighted is that there is a graduated enforcement of this rule. An entity has to receive 2 written rules before a citation is issued. And I think it's really important to understand what that points to is this rule is going to be enforced against rogue operators. This is not something that is going to be easily applied even by the most zealous law enforcement agency or public health department against someone, a business that slips up once or twice. There's just not an ability to do that based on the framework of this rule. And I want to thank the administration and the department for making sure that the rule is written that way. I think that is very important. I think it's also important to stress that the element of local control remains in this rule. And the penalty cannot be carried out. No one can be fined unless the local state's attorney brings it to court and the local circuit court judge agrees that there's a violation and the penalty should be implemented. I suspect, just my opinion, that both the opponents and proponents have overstated the effect of this rule because of that very reason, because of local control. I suspect that in parts of the state where these guidelines are not being followed, you are not going to see an overzealous enforcement now that this rule is in effect. And I suspect in places where locals are already enforcing these provisions, that will continue to go on. There will be exceptions to that, but I think, generally speaking, that's what's going to happen because that element of local control stays in place. Finally, the procedural questions. and I believe my colleagues have brought up legitimate questions, and questions that we're supposed to bring up here in Jcar. I've heard some criticism of Jcar in the last couple of weeks, like, wow, they're so wedded to process. Well, that's why the committee exists. I think Senator Schimpf said something to that effect. But having said that, I believe that you have followed the procedure here. The public health code is filled with dozens, maybe hundreds of provisions that were adopted through the rulemaking authority, as you are doing here. So for those reasons, I'm prepared to support this rule. And again, I want to thank the tremendous amount of work that's been done and the promise of the General Counsel and of the Department to continue to work. If we see that the intent of this rule is not being followed in practice, I think we can go back to the drawing board and consider a mandatory rulemaking, an amendment to the emergency rule in order to address those things. And I want to thank you for that. I understand. Would someone like to make a motion? Representative Reich?
Mr. Chairman, I'd like to propose a motion to oppose and suspend the rule, please.
Representative Reich makes a motion. I believe it's seconded by Senator Schimpf. Please read the motion.
With respect to the rulemaking of the Department of Public Health titled Control of Communicable Diseases Code, Jcar object to and suspend the department's adopting, by emergency rule, enforcement measures that provide enforcing entities extraordinary discretion to enforce the face covering mandate without providing businesses, services, facilities, organizations, schools, and daycare facilities with advance notice that action may be taken against them and what specific standards they will be held accountable to. As this rulemaking does not contain specific standards that affected entities will be held accountable to, enforcing entities can exercise greater discretion in making determinations, leading to inconsistent application of the policy statewide. Existing statute and rule provide applicable procedures by which DPH can address public health emergencies and the process it must follow in doing so. Redirecting those procedures to target businesses, services, facilities, organizations, schools, and daycare facilities is a major deviation from the policy that has been enacted by the General Assembly. Those policies should be changed, if necessary, by the General Assembly, not an administrative agency. Jcar finds that adoption of this emergency rule poses a threat to the public interest because it violates the IAPA and fails to enact the required standards by which businesses, services, facilities, organizations, schools, and daycare facilities will be required to comply.
Okay, a motion has been offered to object and suspend the rule. I will point out to those joining us here for maybe the first time or listening in that such a motion requires 8 votes to carry. Clerk, can you please take the roll?
Senator Cunningham? Senator Cunningham?
No.
Senator Curran? Senator Munoz? Senator Rezin? Senator Schimpf? Representative Demmer? Representative Halpin? Representative Hurley? Representative Reich? Representative Capetti? Representative Wheeler?
With 6 members voting yes and 5 voting no, the motion fails to carry. We will now move on to certification of no objection. Staff, could you please read the certification motion?
The committee shall inform the agencies to whose rulemaking the committee has not voted in objection or extension or did not remove from the no objection list that the committee considered their respective rulemakings at the monthly meeting and, based upon the agreements for modification of the rulemaking made by the agency, no objections will be issued.
Representative Hurley moves that the motion be adopted, seconded by Representative Halpin. Those in favor, please vote aye. Opposed, no. In the opinion of the chair, the ayes have it. Okay, we're now ready to entertain an adjournment motion. Before that, I'd like to announce that the next Jcar meeting is scheduled for Wednesday, September 15th, 2020, in room C1 of the Stratton Building, Springfield, Illinois, at 11:30 a.m. Representative Demmer moves that the meeting be adjourned.